Great. So I wanted to
Let me
say hello to
introduce
every,
you in the
huh?
event for the people who haven't had a chance to meet you just yet. Let me
Oh,
introduce to some and present to others the one and only, our favorite attorney and partner with Velocity Title, the Glenn Russell Donaldson. So for those of our agents that are on the line that are newer to Porterhouse, if you have not yet had the opportunity to meet Glenn, then you will. So when you hear us talk about Glenn all the time, this is he. So Glenn, we're going to turn it right on over to you and allow you to get started with the legal updates for this evening. Thank you so much for taking out your time and joining us. We know you're traveling, but yet you made time for your Porterhouse family. We appreciate you and welcome.
wouldn't miss it for anything in the world. And for those of you who I haven't met yet, I look forward to meeting you soon. One of these days this summer, we're going to do a in-person meeting where I'm gonna come in. So hopefully, I can meet a whole bunch of the new folks when we come into the office. And, we always do something special around the holidays. So I hope we don't have to wait that long, but hard to believe it's only 6 months away. So here we are, right? So one of the things that we have been doing over the last few years and that I really feel is valuable and something that all agents should be engaged in, and that is these kind of classes that Jasmine and Shay and Anitha put on that really help um, give the agents at the Porterhouse team that extra added um, knowledge that's very, very powerful in meeting with your clients. Because one of the things that's probably the most important thing that you're doing for your clients is communicating knowledge, right? The people that are coming to you are coming to you because they don't have the knowledge or the skills about a transaction in real estate, about how to market a home, about how to deal with contract issues, um, how to deal with it, title or mortgage issues as they arise. And the more that you know, the more you are going to stand out to those clients when they're comparing you with some other agent somewhere. And so we think that having this opportunity for you to directly talk with me as a real estate attorney is extremely valuable for you because it does give you a lot of extra knowledge that really most of the agents in the in the community of real estate don't necessarily have the opportunity. Um, so tonight we're going to talk about two subject areas. One, a new law that's going into effect on October 1, 2024, and two, fraud in the real estate world right now. And I have to tell you, it is everywhere. And you have got to be on your toes as a real estate licensee when it comes to fraud. So what I want to do is I want to touch on this fraud case first. And then we're going to get into the new legislation that's becoming effective on October 1st of 2024. And we can even deal with some questions that might come up relating to that. So the the first thing that I want to do is sort of a background of what's happening in the world of fraud in real estate. Um, so let me give you the example of the case that's ongoing as we speak. There are so-called buyers, people who are claiming to be buyers, and generally these people are contacting a real estate agent and they are alleging and asserting that they are from overseas and that they're going to be coming and buying a property here, and they want to work with a local agent to go out, view the properties, and then they're going to get under contract. So what's happening is you're maybe you're sitting at your desk one day and you're getting a call from somebody who's saying, look, I'm interested in a property. These properties are generally between 500,000 and $1 million. So you're generally, normally going to be excited about that. You've got a potential buyer. The buyer claims that they have cash and that they are going to be paying for cash. So they're looking for non-contingent contracts. Again, that's an excitable thing because heck, you're going to get a real estate commission on a non-contingent contract for financing all cash. They generally will let you know that they are not super interested in home inspection contingencies or other things like that. Now, at the same time, they're going to say to you that they are interested in dealing with an attorney or a title attorney at a title agency. And that they want to deposit all the monies that they're going to use for earnest money deposit or anything else over to this escrow agent's account. Now, what tends to happen, and some of the giveaways are, number one, when you deal with these people, they're dealing with you, and they're actually not calling you, they're emailing you. So you're not really talking to an individual. So that's a red flag right up front. They're never available for a call. They're actually using emails. And when you get an email from somebody that is an unsolicited email from somebody who's saying that they want to buy or sell a property, look at the email address and the actual chain in the email address and see what it is. A lot of the times those email addresses will give it away. It'll be something that is almost nonsensical. It doesn't look like a normal email address that you would see. So you want to look at that. You also want to look at the actual language in the email itself. Many times these are generated emails and the sentences don't even make sense. Sentences that are run on and put together and they're jumpy. So if you are reading something that doesn't really make a lot of sense, or it seems like the person might know what they're trying to communicate, but the email is put together very sloppily, that's also another sign that it could be a fraudulent communication. Now, fraudsters have gone so far as to have you write an actual offer on a property, all cash, generally non-contingent, and they're going to put up a $10,000 or $20,000 EMD. They're going to have you send this contract to them through DocuSign or some other form of electronic media, which is not generally abnormal, right? This is something that we do as a normal course, is DocuSign and other things. It'll be signed by them and they will submit it. Then what is also the next step in this, and a telltale sign of the fraud, is they're going to send a check. And the check is going to come as a cashier's check for way more money than was required in the EMD. But generally it's double or more, and it's a random figure that is going to be part of this cashier's check, then is actually necessary under the terms of the contract. So what happens at that point in time is the title attorney or the actual settlement company is going to deposit this. They're going to be required, right, to deposit this cashier's check. And in that period of time, the fraudster is going to ask for a receipt for deposit. And then they're going to say, oh, I overpaid and I'd like some money back. Or they're going to request the entirety of that money back off of that earnest money deposit check. When they do that, they know that a foreign cashier's check, usually drawn, the ones we've been seeing are drawn off of Canada, takes about 30 days to clear. Well, if a check takes 30 days to clear, settlement is supposed to occur within 30 days. That check is never going to clear in time. So one of a couple things have happened. Number one is if they've continued to go through the transaction, settlement has occurred, but the check hasn't cleared. And if they've actually paid enough in to cover the full settlement costs, then the title agency is going to have dispersed based on a fraudulent check. The check won't clear. The seller's money, your seller's money, if you're the listing agent, is going to bounce. And it's going to be called back in. And the deed is going to be transferred back. The transaction is going to have to be unwound, and everybody in the transaction is going to be furious. So when you get one of these, or if you get one of these, and they submit a cashier's check instead of a wire, which is always asked for by the title agency for EMDs or other monies that are part of the transaction, they're not using cashier's checks, then you can bet you better put a hold on things and make sure that your sellers know right away things cannot proceed until that money has cleared, which is at least 30 days, or this person has submitted a wire funds. Their resistance to submit wire transaction funds is a telltale sign of the fraud as well. If you're asking somebody and then to send wire monies for an EMD from overseas and they send a cashier's check, you can almost bet your bottom dollar those people are fraudsters. And it is something that the real estate agents are going to have to be very, very careful of, because if the real estate agent is involved in the transaction and it turns out to be a fraud and you didn't do due diligence, then of course you know what's going to happen. The real estate commission is going to start looking for real estate agents, as well as potential insurance claims are going to be raised against the real estate licensee for covering of losses that will be asserted. If settlement has happened and then after settlement it's discovered that the funds haven't cleared, but everybody's received their money, well, guess what? The real estate licensee can't keep the money. They have to give it back. So people will have spent that money. It's a real problem, and you need to be very, very careful. So I'm putting that out there because I was brought into a case in the last 2 weeks, and that case has turned out to be a complete fraud. And so everybody should be very, very aware that is a possibility. So the next subject matter on our schedule for tonight, the House Bill 693, which is called the Renters or Tenants' Rights and Stabilization Act. And what that is a new law that comes into effect, it becomes effective October 1st of 2024. And so let's talk about, and let me just get it up here. Bear with me. I'm going to do that real quick. I want to get all the details up. All right. So let me look at the first part of this. A right of first refusal is a right granted in law to a tenant And that right allows the tenant to buy the property as a right of first refusal over any actual contract from a buyer. So let's talk about the transaction and how it would happen. And the District of Columbia, by the way, in Baltimore City, has a right. This is an entire, already has a law in place for that right, but this is an entire new law for the state of Maryland, the whole state of Maryland. And so what you've got is a right that a tenant of a property that you are listing has to negotiate pre-listing with the seller or landlord. So if a client of yours contacts you and says that they want to list their property and it's a rented property, then what they're going to have to do is provide the tenant with a notice, a solicitation notice of an offer of sale. And that offer of sale is going to contain the terms that your seller would accept in the event that they would get a contract. All right, so what does that mean? Your seller has contacted you, and when they've contacted you, they've said, we want to list our property. You cannot list the property until there's an offer made to the tenant. And the tenant will have 30 days to respond to the notice with an actual offer to purchase the property at the terms that the seller has agreed to accept. And it has to be of equal terms or greater terms than what the landlord or the seller, your client, would accept. If the offer does not meet the material terms, then the landlord has to deliver a counter offer to the tenant. And the tenant will then have 5 days again to accept or reject that counter offer. Now, you can already see if you've got a seller who has a property that's rented, you're 35 days before you even get into being able to consider listing the property. So now once you've got that, the tenant has 5 days to accept or reject the offer. If the tenant does not respond to the solicitation or the counter offer, then the tenant's rights would be deemed by law to be extinguished, okay? So, and what that means is, and let me just back up a second. You must have every detail of this in writing. If you don't have every detail of this in writing, you're going to find yourself in a world of trouble. None of the notices can be oral. They cannot be oral. Okay. So when you get, and you're going to get these, and when you do, then you're going to have to go through these steps. All right. Now, the second part is after. So you've got to give the tenant the pre-listing offer. And now, so you've waited 35 days, right? Before you can even consider listing the property. Now you've listed the property, and an offer comes in. The tenant will have additional time. So let's talk about this. You've followed all the procedures outlined in the first scenario, pre-listing. There's no agreement between the landlord and the tenant. The landlord will subsequently receive an offer to purchase the property. And it must be at least 10% equal to, or at least 10% less than the lowest price previously offered to the tenant. And we're gonna have to look at that in an example very closely. You're gonna provide notice to the tenant again, and an Office of Landlord and Tenant Affairs, which is being created here for this new legislation. There's an Office of Landlord and Tenant Affairs. And you will identify in this notice that the tenant has a right of first refusal. The tenant will then have 30 days again to deliver a notice of acceptance to the landlord. And the Office of Landlord and Tenant Affairs. So now we're 60 days. The buyer who has submitted a contract is sitting for 30 days after they've submitted a contract, just to find out whether or not the existing tenant is going to exercise their right of first refusal. If the tenant delivers an offer at the same price, then the landlord must accept the offer, and the tenant gets the property. The buyer who sat there and waited for the 30 days has no rights to exercise their contract. It's subject to. Now, if you get one of these, we have got to make sure there's language, and I'll talk to Jasmine and Shay and Anita about this. We have to talk about language that the new buyer's contract, that new buyer, that third party buyer that's out there, is told that their contract is subject to this legislation, this law, and subject to the tenant's right of first refusal. Because in theory, if you don't have that language in that buyer's offer and contract that you want to accept, then the seller could be in contract with two parties and in violation of the law. So we want to make sure that we have that language appropriate, that any contract that's coming in is going to have that subject to language. Once the landlord notifies the Office of Landlord and Tenant Affairs that the tenant has exercised the rights, now the tenant then has to go out and get their loan. They don't have an absolute requirement to have loan approval at that point. They just have a right to get under contract. So they then now submit for loan application, and in loan application, they don't get approved, your poor sellers are going to have been out for the 35 days, an additional 30 days, and then at least an additional 30 days written in the contract. So we're over 90 days, and the seller could find out that they can't sell the property and have to start all over again with another contract. And if the tenant is still in the property, they've got to go through all the notices again. So we're going to have, as real estate professionals, we're going to have to be very careful that we provided the proper required notices to our sellers, our listing agents, give this notices to the sellers to make sure that you've covered your own behinds, as well as you put your sellers on notice. Hey, If you're renting property and now you're selling this property, you had better be aware of this law. I'm gonna put together something and send it out to everybody. I'll probably be able to send it over to Jasmine tomorrow, and then they can get it out to everybody, so everybody has some notice. Maryland Association of Realtors does have a breakdown on this too. I'll probably just go ahead and cut and paste that, because theirs is pretty pretty cohesive and pretty exact as to the law. Now, there's a third part of this, right? And that is where the seller may or may not have an actual listing, but they get an unsolicited offer to purchase the property from some third party. It could be from you as a real estate agent who represents a buyer who wants to buy that property, is interested there, and the landlord receives an unsolicited offer. If the landlord decides that they want to accept that offer, they must again go back through the process of providing notice to the tenant and to the Office of Landlord and Tenant Affairs of the tenant's right of first refusal, and the 30-day clock starts to tick again. If the tenant decides that they want to buy it, they must provide that written notice to the landlord within that 30 days, and then they have, again, whatever their contract term is, to determine whether they can afford the property and get qualified to buy. If the tenant does reach a successful conclusion, the Office of Landlord and Tenant Affairs will be notified. That's going to be on the real estate agents, I'm sure, because the landlords are not. Now, there are some exemptions. Landlords who are transferring properties with 4 or more housing units are going to be exempt from this law. If you transfer to a family member, then you are exempt from providing the tenant with that right of first refusal. Let's say your landlord, your seller, owns the property in an LLC, and they want to convert to a new LLC for whatever, estate purposes, tax purposes, whatever the reason, they will be exempt. All court-ordered transfers, a court ratifying a transaction subsequent to litigation, those will be exempt. Transfers by a fiduciary who is a personal representative out of an estate, administration of that estate, guardianships, all of those transactions will be exempt. Obviously, if you come across one of these and you're not sure, you're just going to reach out to me. We'll make sure that you got your boxes checked, so that you're in safe harbor here. Not that you're going to have these, but occasionally a real estate agent will get one, and that's a transfer of any property to a governmental agency or a public housing authority. All of those are exempt from the tenant right of first refusal. Notices, they're all going to be given through first class certified mail. You're going to want to make sure everything is in writing. The Real Estate Commission has put that out there, not to mention the statute of frauds that we talk about all the time. All things with real estate have got to be put in writing, period, full stop. If there's any financing conditions, then those terms are going to have to be spelled out in the notices, all right? A lot of people ask the question when these rights of first refusal come up, can the tenant waive their right of first refusal? And the answer to that is no. The government, right, for whatever reason, the government always feels that they know best. So they have prohibited people from waiving their right of first refusal, which is problematic. in my mind, for different issues that we don't need to get into tonight, but people are not allowed to freely negotiate their own contracts. Government's gotten in and decided who can do what. A person who violates this law, number one, can be civilly liable to the tenant, and number two, can be subject to $1,000 fine for each violation. So, you just don't want to find yourself in that position, because if the landlord is found liable, they're going to come after whoever their agent is. So you want to make sure that you're very familiar with this. This state law now will preempt any local law. So Baltimore City has a local law. The state law will preempt that. Any other jurisdictions that have rights of first refusal provisions, they will be preempted by this as well. Some of the other changes that are going to be made to this is landlords are not going to be able to charge any more than a 1 month security deposit period, full stop. So you're not going to be able to, sometimes people charge first and last month, and then the first month's rent. So effectively 3 months worth of payments. That's not going to be allowed anymore. So it will be prohibited. We don't need to really get into the evictions and filing fees. They're just going to go up. The state has increased the eviction costs for landlords. We don't need to get into that here. The real issue that we wanted to touch base is on the rights of first refusal. Okay, so that covers really that new law in a nutshell. Does anybody have any questions about either one of the two subjects, the fraud issue and the example we talked about that we're dealing with right now, where there's a fraudulent buyer coming in and giving a cashier's check, which is, that's always a telltale sign. Cashier's checks can be frauded so easily. And then this landlord tenant issue. Does anybody have any questions on those?
Lynn, there are lots of questions, especially in the office. Of course, we're hybrid, so we have everybody online as well as in the office. The first question I'll ask is, as it pertains to the similarity of TOPA in DC, will these rights be retroactive? So like in DC, it includes tenants who are currently occupying the property, as well as anybody who's occupied within 6 months of the time that the owner decided that they wanted to sell. Does this become retroactive, or is it from the time that the landlord decides to list?
No, that's a great question. Right now, the way that this law is written, it's at the time the landlord decides to list. Now, one of the things that TOPA has as well is assignees, right? It's the tenant or assignee. Maryland's law is going to have the same thing, and I'm actually at the DC Supreme Court on a case about the right of first refusal to a tenant in DC, where it wasn't the tenant at all, but the tenant just decided they were going to assign their rights without the landlord authorization over to an assignee, and the assignee asserted the rights against the real estate agent. They asserted the rights against the landlord. So, that's going to be something that we're going to have to keep an eye on. But it's a great question, and what's going to, happen is some of this is going to play out a little bit, and they might tweak it, Jasmine, between now and October. But as of right now, it's from when that landlord wants to list the property.
So then effectively, the landlord should be able to remove the tenant or wait until that tenant's lease expires before they decide whether or not they want to list. Is that the case?
That is correct. So if if the lease is getting ready to expire, great, right? You can just go ahead and wait until they're out. Once they're out, you can list it, and it's not
Perfect.
retroactive back to 6 months prior.
Thankfully so, okay.
Yes,
Because he is, okay.
because this law is already time consuming enough. A seller could really be in a pinch for, as I see it, up to 6 months.
Wow, okay. Well, that's a silver lining that they can list
Yes,
it if that lease is expired or when it's about to expire, they can move forward then.
right, exactly. Yeah.
That's good to know. We have some questions in the office. You're gonna come up here so that Glenn can hear you. Okay, Anita's gonna unmute.
Okay, right there.
Hey, Glenn, it's Carmon.
Hey, Carmon, how are you, buddy?
So, here's my question. First question. So if a landlord has a tenant who's in arrears 2, maybe 3 months,
Great
and they're in
question.
the process of even trying to evict, but yet they want to sell the property as well because it's been in arrears, they've lost money and everything is going south. So you're saying that tenant who's in arrears still has a right of first refusal to buy the property that they can't even pay the rent on?
Yes, sir. Believe it or not, it's a great
Wait, we
question.
can't hear you. We missed you.
Yes. Believe it or not, that's absolutely correct. The tenant will still have the right of first refusal to purchase on a property they can't even get the rent payments made timely on. So unlikely that they would be able to qualify for a mortgage to buy it. But if the tenant wants to frustrate the landlord and frustrate the transaction, they can do so by exercising that right.
Which gives them a chance to stay there even much longer and
That
slow
is
everything
correct.
down.
That is correct. Yes.
So Glenn,
Yes.
so there is, I guess the state feels like there was something that was lacking. And so that's why they came up with this right of first refusal in Maryland. What is the thought as far as, the protections or who are we protecting and or accommodating, I guess, through this, that this is now necessary, that the state sees that this is now necessary to allow the right of first refusal to tenants?
Yeah, no, it's another good question. So that the idea behind a right of first refusal is so that the tenant doesn't get displaced, right? So historically, the example would be that you would have a tenant living in a property maybe for years. And at some point in time, the landlord just decides, I don't want to be a landlord anymore, and I want to sell this property. And you have to get up and leave. And so the tenant can be displaced. And so the idea behind the right of first refusal laws throughout the United States has been one that says, if a tenant is willing to pay a price that the seller could get out on the open market, then they should have the right to be the first one to buy. Now, the idea in theory is not necessarily a bad idea, because if a tenant legitimately can afford the property, they can qualify for a mortgage, and they decide, I don't want to move. I don't want to move. My kids are in school. They love it here. We've been here 10 years. We could stay here and we could buy this home. Then, that's a good result for everybody. what's happened is the state has gotten more and more and more, and it's not just Maryland, DC is pretty, their TOPA rules are really problematic. There's a lot of problems with those TOPA rules in DC, the way that legislation is written. And I can see it here too. The idea of a 30-day window for a tenant to make up their mind as to whether or not they want to try and submit an offer, that's too long. It puts everybody in the transaction in a holding period. And so a buyer who's wanting to buy may have an interest rate lock that they're not able to maintain, while they're waiting to go through all this decision from a tenant. So it's a nice idea, but in practice, it's difficult to implement and be fair to the sellers and other buyers out, trying to buy property. And it's difficult right now for buyers to find good property. So if a property comes on the market, and you're representing that buyer, you want to be able to get them in there as quickly as possible.
So actually, Ronald, on Zoom, he asked how many times when you were talking about countering, he asked how many times can the tenant keep counter offering and hold up the sale if the third party wishes to purchase the property?
So if the third party has submitted an actual contract offer, then the tenant must meet or exceed that offer. And so they really can't negotiate at that point to frustrate or hold up the third party's offer. It's where the tenant and the landlord are negotiating pre-listing that the seller can play these games for a bit. But the seller ultimately is going to come to a conclusion as to what the value of that property is. And within 30 days, 35 days, really, with the 5 additional days to reject, counter, and reject, counter. So the answer to the question is the tenant can do it for 35 total days pre-listing. They have that 5 days. Once the seller says, this is what I want, the tenant can play games for 5 days. At the end of 5 days, if there's no meeting of the minds, the landlord can proceed.
Okay.
Mhm.
Okay, so my question is, do you see now there's going to move to where a lot of landlords are only going to do month-to-month leases, month-to-month, instead of having the annual lease, just do a month so you can get them out. And once they're gone, this does not apply from what I think I heard you say. Once they're out.
Yes, I do see that. I do see leases, becoming shorter term to give more flexibility to landlords. Certainly, if it goes, the first year, after that, they'll probably just go month to month. Most landlords are just going to go month to month. And some landlords may start on a month to month lease right up front.
Right up front, right. Which would make sense.
Okay,
But
go ahead. Mhm.
I think I heard you also say, though, if it's a 4-unit building,
Mhm.
it has to be more than 4 or 4?
Or more.
4 or more.
Yes,
I'm thinking about Mr. Ford. 4 or more, and it's exempt.
it's exempt, correct.
Good.
That's if now understand, that's if the landlord is selling the entire unit and it's 4 or more. Okay. It's not like a quad or duplex and they're separate titles and one landlord owns all of the units but only wants to sell one of them, then it doesn't apply. The landlord will be subject to it. But if the housing unit contains 4 or more than a housing units, right? And the landlord is selling everything as a whole, then they're exempt. Does that make sense?
Yes, it does.
Okay.
There's no more. Are there any other questions from anyone who is joining us via Zoom? You can unmute yourself.
I have a question, but it's not on the subject.
Hi, Darlene.
Hello. So Glenn, I have a situation.
So, okay, so,
I can
Darlene,
wait.
yes, please, if you don't mind. Okay,
I'm
so
sorry, I missed that. What was that?
So we're going to make sure that we just take questions on the subject, and then we'll move on to the, right.
Yeah,
to,
sure. Darlene, I can touch base with you tomorrow and we can go over your specific question.
Uh,
Okay.
Okay, great. Yeah.
Thank you, Darlene. So any questions regarding any of the fraud that Glenn was speaking of initially? Okay, anything else?
That's
Ms.
good. That's
I
good. That
I
means
can't
probably
think what
nobody's
is-
dealing with one of those right now, which is good. But my guess is it's not going to be long before somebody at Porterhouse is going to have one of these transactions.
Right, okay. And Mrs. Porter, anything from you?
That was such great information, Glenn. I can say I'm not excited to know that Maryland is going to become like DC, but I'm certainly happy that I'm used to navigating those type of waters because we've been dealing with
Yes.
that in DC and Baltimore for a very long time. So
Yeah.
yeah, the good thing is that well, it sounds like in Maryland, it's going to be a combination of two things in DC. In DC, you have the opportunity to give them the opportunity to purchase with a third party contract and without a third party contract. You get to choose, but it sounds like in Maryland, you have to do both. You have to give them the opportunity before you even get a contract and then an opportunity when you get the contract. So
That is correct. It's the dual step here in Maryland that you don't have in DC.
yeah, yeah, it is. I agree. Let them finish their lease and then you list the property.
Right. Yep. Now, you know, and the challenge for sellers there is, well, okay, now they finished the lease and they're out. And now that house might be vacant for a while. And so there's no revenue coming in for that landlord during that period of time. So it's not a really attractive scenario, but it is the best way to go. Because otherwise they get delayed up and down one side or the other.
For sure.
Have exercise over in,
Can you hear Anita?
No, I can't, I couldn't hear her exactly.
in my opinion, it probably is still worth it to just wait until the tenant lives out their lease, because you'll have people who are who's familiar with TOPA from DC and
Yes.
just come to Maryland and, you know, I've exhausted everything in DC, so I'm moving on to the next state.
Yes. Yeah, good for you. DC is frustrating. It's unfortunate that it's really become a mess. I mean, this court case I've been in on this TOPA case has gone up to the Supreme Court of DC and back down to the trial court and then back up again. And we're into I think we're in year 8 now over this thing. It's really amazing, you know. So the client, the poor clients, you know, the owner of the property has been in this for 8 years. It's cost more in legal fees than he ever made in the investment. So
Right.
it's not fair. It's not right.
Yeah, yeah. Okay, so we just wanted to see, Glenn, thank you so much. We wanted to see if you had a couple more minutes, and then if so, we
Sure.
could let Darlene go ahead and ask her question.
Yeah,
Or,
absolutely.
yeah.
I do. I'm good. Yeah.
Oh, great. Okay, go ahead, Darlene.
I thought he mentioned that he would just call me tomorrow.
I can, whatever you prefer, Darlene, if you would like to ask it
It
now.
doesn't matter. Okay, so basically, I'm trying to make it short. So
Sure.
we have a buyer who got an offer accepted, so on and so forth. Seller wants to, well, she sent a unilateral to release the
Okay.
release them from the contract because she said she had a judgment against her home, and it exceeded, I guess the proceeds, blah blah blah. So we're now with over, I sent the ratified contract to Cheryl, and she's just actually just trying to go through and make sure, what the seller is saying, pans out. Because what I have is I do have a copy of the lien, but the one that she's
Okay.
saying, one of them is for IRS and the other is for I guess the husband was a builder.
Okay.
The tax lien, I see at one point it had a partial release, but what she sent me is the one that says it's basically